Morning, everyone. Buenos dias. We're bringing all sorts of languages. I was really excited to learn some Haitian Creole this morning. If anybody is available for lessons, I could use more afterwards. I'm really excited to be here on the stage with all three of us are attorneys. We'll try to keep it short. We can't make promises. But we're really excited to follow some really great conversations around technology and music, and we're going to hit that intellectual property side that's been touched on here and there in these other discussions. So I'm going to let my co-panelists introduce themselves. I'm going to start first with LaShawn Thomas.
Good morning, everyone. My name is LaShawn Thomas. I am an attorney with Miami Entertainment Law Group. I have been practicing law now for about 13 years. I've been extremely fortunate with the caliber of talent that I represent. I'm general counsel for the Miramar Amphitheater in the Wasco Arena at University of Miami. I am also lead counsel for Johnny Gill and Ralph Tresvant and the supergroup New Edition. I've also been blessed to represent individuals such as Janet Jackson, Wendy Williams. I represent the family of Mika Ben, who's a really well-known Haitian artist who passed away, unfortunately, tragically, a few years ago. So I am very happy to be here. I do a lot of music catalog representation, a lot of acquisitions and sales. So thank you very much for having me today.
Good morning. My name is David Millian. I am the founder of the Millian Legal Group. I've been a practicing attorney in South Florida for 34 years now. My emphasis is litigation. Intellectual property litigation is a focus of my practice, including copyright litigation, trademark litigation, anything in the artistic space. That takes me to federal district courts here in South Florida, New York, California, Illinois, where these interesting cases under these federal statutes get fought over. So when LaShawn's clients run into trouble and there's an infringement claim, someone like me or me gets called on the phone, and I usually get a story about here's the history over the last couple of years of what's going on, and there's a dispute over ownership. There's a dispute over whether there's an infringement, somebody copying somebody else's work or getting too close to it. And I go in, and if there's already a lawsuit pending, then I'll jump in. Or sometimes I get called because my client thinks that somebody else is infringing their work. And so we will start that process. So this is exciting. I'm excited to be here. Great topics so far, and looking forward to having a fun conversation about how the law and AI are coming together at this point.
Yeah, and I'm Jessica Neer McDonald, born and raised here in Miami. I am the managing attorney of my law firm, Neer MCD. I'm also head of global trademarks for Midjourney, a text-to-image AI generator, and I represent artists to technology companies and in between. So this topic, especially, global rights management, touching on AI, blockchain, all that is especially exciting, and I'm looking forward to getting into it. Do you want to start us off, LaShawn? I'd love, let's dive into a little bit about music creation and copyright management. So we like to hit some of the basics first, because when we're talking about rights management, we're primarily talking about copyright, though we had some discussion, there was a discussion earlier about rights of publicity, so rights over maybe your voice and name likeness. But let's start with copyright, and can you tell us a little bit about copyright?
So this is intellectual property 101. So what is a copyright? A copyright is an original work of authorship that is fixed in a tangible medium. So what does that mean? That means it can be a photo, it can be a book, it can be music. It has to be original, and it needs to be fixed, right? So I think that is also part of the reason why you're having such a debate about whether voice will properly be classified as intellectual property and therefore protectable. Generally, for the most part, you've seen instances where someone is making a claim of, is this mine? Can I protect this? How do I protect this? In the United States, and we're just talking about the laws here, you have the Library of Congress, the Copyright Office, and generally that is where you would submit an application for the protection of this right. Now, that is not a mandatory step to take. It is a very smart step to take, because once you do submit that application to the Copyright Office, you are now protected by the full force of U.S. jurisprudence, meaning if someone does infringe upon this copyright, now you have the ability to demand attorney's fees, which can be very expensive in cases like this. In some instances, statutory damages, some of that has changed, because at one point you could get it, the difference between actual use and what the statutes grants you the right to receive. So when we're talking about copyright, we're just talking about the protection of your manifestation of an idea.
I love that. And you need a copyright registration to get to court. Right, David?
Yes, you do. And I thought the earlier discussions we were having about what the AI platforms now allow you to do to create these things so quickly, things that would take weeks in a studio can now be done, fairly quickly with AI generative assistance. The issue then becomes, though, great, you've created this phenomenal piece of work. It's music, you've got great lyrics, you've got a beat behind it, and it's yours, you created it, and you put it, let's say you upload it to some platform, and somebody else comes along and says, wow, I really like that. I'm gonna use that as the jingle for my business. Or I'm gonna take that on the road and I'm gonna use that to introduce myself at all these conferences. And you look and you find that out and you say, wait a minute, I created that. How is this person using my creation that I was able to create so quickly? Well, did you attempt to register that creation with the Copyright Office? If you didn't, your remedies are very, very limited. You're not going to be able to sue in federal district court. You're not going to be able to claim all those wonderful rights that most owners would be able to claim in court. You're not going to get those statutory damages. You're not going to get those attorney's fees. You're basically out of luck. And if you came to me under those circumstances and you wanted to pay me a lot of money to prosecute your case, I could write a few demand letters, but I would tell you up front, there's not a lot you can do. There may be some state law, depending on the state where you are, that you could try to enforce some of those rights depending on the facts. But unless you've registered that wonderful work that took you all that time to create with the Copyright Office, you're not going to be able to enforce those rights. And then, music, what kind of registration are we talking about? You can register the lyrics. Originally under the 1908 statute, which is the statute we're still operating under here in the United States with some amendments, you would register and deposit the sheet music. That's still done because the sheet music's very important. That's the chord progressions, the notes, etc. You register the lyrics. If you've recorded the song or the work, you can register the recording. But if you don't register each of those, then you don't get protection for each of those types of things that are out there. So that's why registration is so important to protect these wonderful creative things that you all come up with. Without that, you have a nice piece of work that anybody can basically use for their own purposes.
I have a question for you. One of the things that I notice when I'm working with artists is that they don't do something as simple as letting the world know that you are claiming ownership of the work. We don't use the ledger. We don't use the C in the circle and the P in the circle and the year and the owner, which is very important because that starts with identifying who the owner is, and it lets other people know, hey, well, if I'm looking at this property, there's someone somewhere that takes their craft serious enough that they want the world to know if you want to utilize it, come over here. It's basically the calling card, and for the most part, most people don't utilize something so simple. It's almost like a smiley face for your work. So, that's one of my kind of practicing tips.
I love that too, because if somebody likes that and they want to ask for your permission, where do they go? Right? So I'd love to hear more about what happens when they say, where do they go? If you get a client that asks you that, I want to do things, quote, the right way. I want to get the permission. When we talk about licensing, we're talking about giving permissions to others. How do you guide clients through that?
So I'll tell you the beautiful part about advancing technology that I love now, and it is blockchain, because now blockchain is like that tracker, that identifier that will tell the world, hey, this song belongs to this person. This is what you need to do to utilize this song, because or whatever it is. Because right now, when I have someone that comes to me and they want to utilize someone's work, I've got to go on basically a hunting expedition. I've got to figure out who the administrator of that work is, whether it's Sony Music or Sony Pictures or some person's wife, because he passed away long ago, and so now she's the executor of the estate. Because, as we're saying up here, in each, especially music, body of work, there's actually two bodies of work in that. So you've got to go and ensure that you're asking all of the right entities for permission to utilize one body of work. And so there could be different things going on. There could be multiple agreements that are in place, exclusive or non-exclusive, territory, term. So those are all of the things that I've got to figure out when a client comes to me and says, hey, LaShawn, I would like to sample this song. And, I do have some clients that they don't just go for it and face the consequences. They're kind of the school of seek forgiveness and not permission, and those are often the ones that
They then come to my office. Yeah, exactly. Yeah, always better in this economically and just from peace of mind to seek permission first, not forgiveness. Forgiveness in this realm is really expensive. Either way you look at it, so absolutely.
I love that. And I love the reference to blockchain technology, especially public blockchains where you might be able to see transactions or be able to trace ownership, trace provenance. The potential there is just so high, and I've seen some come and go in that space over the last couple years. But can you tell me a little bit more about what you're seeing in this space for the music industry?
So what I've been noticing, especially during COVID, as we know, COVID really created a seismic shift of the industry. There were a lot of people who were surviving solely on live performances, things such as that, and all of a sudden the world stopped and they still had bills to pay. So I started to get a vast influx of individuals who wanted to get their master catalogs straightened out. They wanted to find out, how can I exploit that? Am I earning the proper amount of money? They started paying close attention to who's utilizing my catalog without my permission. So, from going from that angle, I began seeing a lot more of entities popping up that were wanting to actually purchase these catalogs. And I've had a lot of clients to come in and say, I really need to sell it. I really need the money. So then my job became to go out and find chain of title, who that producer is, who co-created this song with them, who owns rights to it. So a lot of my day is spent doing that, more administering the catalog so that we can prep it for sale. And then there's entities that, you can offer your catalog to. There's third parties. They have these websites where they can auction off your rights. They can put it up for the highest bidder. A bidder will come in and say, hey, I want to give you this amount of money for that catalog.
You're staying very busy. It seems definitely very neat. And these assets, copyright, just like other intellectual property assets, can be collateralized. And so I think that's a very important thing to keep in mind. We were talking about the great benefits of having a copyright registration, aside the fact by once it's fixed in a tangible medium, you own the copyright. Okay, then it's a question of, are you going to take that next step to go apply to register it at the Copyright Office? Relatively inexpensive process. If you're waiting to get to litigation, then you're paying the expedited fee of $800 plus. So those are some things you're considering. But also in holding that asset, that's something that you could be used as collateral. Can you talk to us a little bit about that?
When you say collateral, in what terms do you mean?
Yeah, I was thinking about your work with music catalogs specifically. So somebody wants to acquire it, or somebody wants to use it as something to put it against for something else. So kind of like a mortgage of sorts.
So what I see with that are loans. Generally, actually, I'm in the process of a catalog sale right now where the gentleman needed some funds, and so the sale is going a little slow because the major label has matching rights to this catalog, which means even though the catalog was placed up online for sale and we have a bidder, the major label now has the right to match the offer that's currently in place. And of course, the deal wasn't a match, and so I had to kind of go get so crazy on them, like, give me a match or I'm selling it to this guy and I don't care what you think. So while we were waiting to do that, he went out and he got a loan. And so what a lot of people don't realize is that BMI, ASCAP, all of these entities, they will allow an artist to borrow money against their catalog. But one of the issues that a lot of times these artists face is they don't have full ownership of this body of work. And so when they go to sell it, then I have all of these chain of title issues, and then I've got to go and have someone like you come in. So how do you propose that issue is addressed as far as two co-creators battling each other because one wants to sell and the other one doesn't, because you do have certain rights where an individual can sell their half of the copyright. How do you resolve that?
Yeah, so breaking it down to like a very easy example, you have music. You have one author who wrote the lyrics, another completely different author wrote the melody. And so those are two independent rights. They're co-writers. They each own copyright interests in that body of work. And so now, let's say it's a hit song, and this is not an uncommon situation. And the work has been out there exploited for years. It's been in movies, it's been in television. One of the authors passes away. This is a real example. And the family, under the copyright law, inherits for a certain period of time the rights that the author had. So the author of the one who wrote the lyrics now owns the rights to the lyrics, but the author who wrote the melody is still alive and may not want to do anything with the song. What happens? Well, unless you just want to license the lyrics, like just put the lyrics in a book you're writing, then maybe you can make a deal specifically with the family members of the lyric writer. But if you want to put the entire song on a documentary or a piece of a movie or a commercial, you're going to need permissions from both. And certainly if you want to sell the entire catalog, the recordings, the actual lyrics, and the melody, you're going to need permissions from both. And it's a negotiation. You can't have one without the other. And in this sort of cut and dry scenario that I'm talking about, it's almost impossible, really. How are you going to just acquire half of the creative work when it's the entirety that is the most valuable? And it involves sometimes years of negotiation. And if one side eventually does come to the point where, look, this can be sold both sides can be happy. Maybe the family that owns the lyrics purchases the author that wrote the melodies. That's happened as well, and now this family now owns the entire work and can then exploit it, sell it, etc. But it's a negotiation.
Yeah, in the ideal world, you handle that before it's created, right? You outline it in agreement. When does that ever happen?
Right.
But it's it's something to think about, right? It's always nice. Like, just I love to tell our creators to treat it like a business, right? To get your contracts in place. Might sound silly, but write it out. Talk it through. Who's going to own what do you want to do with it? What's the vision here? I love that you brought up the example of, and this very well happens, and we saw this play out in an AI example. So here's the pivot to AI, right? Is a certain somebody came out with a track. It had the voice of Tupac Shakur, no longer with us, or maybe, I don't know, but
He's with Elvis.
and Snoop Dogg. And the reaction I found was fascinating because Snoop Dogg thought it was hilarious, loved it. Tupac, didn't publicly come out, but his family had a problem with that. So it gets to this conversation of, you never know what's going to happen, but we're seeing a lot of lawsuits related to AI generated works. Do you want to fill us in a little bit about what's going on and what are AI generated works, right? Because we're really looking at a spectrum.
And who is the creator? Because is it the computer program? Is it the person that wrote the computer program? Or is it the person that's controlling the computer that created? Like, who is the creator?
Yeah, and so you have a situation, so the interested parties are the artist who has just created this work and is finished with it, has used some AI tool to create that work. That's one interest. You have the original content providers, people who have created works that are protected by copyright and for the most part have been conveyed and are effectively owned by publishing companies, and they have the rights in those works and they want to protect them. Then you have the AI platforms that have, through their training algorithms, scraped and scoured the data and have now, through AI, incorporated in their database all of this vast creativity, from melodies to lyrics, et cetera. And that's part of what the AI database contains. And they've trained on works that are protected by copyright. And so, going back to the first party that's interested, which is you're a creator today, you want to create something and use AI tools, a song, a jingle, what have you. And you use a platform and you go on and you prompt it and it comes out with some lyrics, possibly a melody. Understand that from the perspective of the publishers and the content providers, the output is an amalgam, a combination of a bunch of, and depending on your prompt, it could be actually one or two, but several works that are protected by copyright. And the challenge here is to determine, which works are being used for your new work and which, aren't. So here's where the dispute is. First, let me back up. If you wanted to register a copyright work that has some AI input, you need to disclose it, and you need to disclose it with specificity. Which part of this creation consists of AI and which part is human? Because at the end of the day, the copyright intellectual property is to protect original works created by human beings. We can go down, there were efforts by chimpanzees to register their works. Supreme Court said no, it's human beings. So to the extent that the work has human input, there's a potential for it to get registered for copyright, but you do have to disclose what, other than a very de minimis amount, if you've used AI, what aspects are involved AI. So here's what the recent disputes are about. The platform, I'm I'm going to get it wrong. It's a Tennessee case, Anthropic. So Anthropic
Claude.
is an AI platform. It's music, has a lot of music, AI potential and data in it. It is being sued by almost every major publishing company on the planet. It's in the Western District of Tennessee, which happens to be where Nashville is. And the primary claims are that, you know, if a user prompts the platform to create a poem about Alabama in the style of Leonard Skinner, well, the output is almost verbatim the lyrics of Sweet Home Alabama. And so the allegation there is that's, you know, it's not being attributed. It's just, here's your poem without any of the caveats and protections that the original authors to the lyrics would insist on. And, you know, there are multiple examples in this lawsuit, and the allegation is that that's copyright infringement, that the platform itself, in acquiring all this vast amount of data, putting it through the black box, which is the AI generator. They call it a black box for a reason. Nobody knows what happens once the data gets into that black box, including computer scientists. But then it spits out on queries all of this really, what seems to be, could be unique generated data. But in many instances, it's very clear that in the examples that they cited in the lawsuit, it's taking directly from specific artists who have copyright registration protection, and that's, you know, an issue. What are the defenses? Well, you know, again, we're operating under a 100-year statute to try to address technology that is cutting edge, and, you know, we barely understand it, and the law is always, you know, never mind a few years, sometimes decades behind, and it's trying to catch up. So in defense, Anthropic is saying, hey, this is just fair use. It's no different than, you know, if we were writing a textbook and wanted to quote a poem by Maya Angelou to teach the world about African American history or the arts. That's fair use. The law is very clear on that. You can do that, okay? And that's what these platforms like Anthropic are claiming, this old fair use defense, which is 100 years old. They're saying that's our defense as well. I'm not pessimistic or optimistic about the litigation. It is what it is. We go back to Napster and the uproar of piracy claims that created. We were able to manage through that, not perfectly, but understanding that it created a new world in terms of music and the ability to exploit those works. We had to come up with new models. And so you had, you know, Spotify comes along. The claim against Spotify is, well, they're pirating as well. So you introduce licensing into the mix, and now it's a paid-for subscription where the authors, the creators, also get a cut of the fee. How we manage that with AI, you know, it's going to take some creativity. I think it can be done, and I think that's probably where this is headed, because we're not going to stop AI platforms from producing the output that they produce. We're not going to stop creators such as yourself from using AI to assist you in the process of creating works. And we're not going to stop the original authors of these works who claim that the AI platforms are using their creations to help others generate their creations, from insisting that their rights get protected as well. So I think that the transactional lawyers are going to come up with very creative licensing deals with the publishing companies and the AI companies. Some of that is already happening in the published books, with newspapers. That's already in the works. With music, not yet. You know, Sony just sent cease and desist letters, pre-litigation letters to 700 different entities relating to this AI, alleging theft of their copyrighted materials. Will that result in litigation? It might. Will that litigation then result in kind of this working out of licensing agreements? That's generally how the world has played out in the past. Everyone is entrenched in their position, and then that usually gets worked out. We'll see. I don't know if additional legislation addressing this is going to help. I do think that the current framework that we have can address it, but it's going to require people coming together and working out licensing agreements. If there's no cooperation between the parties, how does this litigation play out? Anybody's guess. Is Anthropic liable for copyright infringement? At this point, I can't really tell. It seems on its face like there might be some, specifically with the claim of, you're spitting out the exact lyrics of my copyrighted song. That might be an infringing act. But again, it's not the artist it's not a single artist that's suing. It is publishing companies suing for vast bodies of work. So how this plays out at this point is anyone's guess.
Yeah, to be determined. And then the lawsuit's very interesting because that one was really one of the first and probably major. I'm not actually aware of any other ones concerning music and an AI platform at this time. And that one's had a motion to dismiss, had a motion for preliminary injunction. And the judge hasn't ruled on it. And the parties had said, hey, can we figure out what's going on here? And the parties still haven't ruled on it. And that's, I suspect, not really sure, that it might be because there are a lot of lawsuits going. It's very nuanced, and there are a lot of lawsuits right now going on in the visual arts space related to images and code, and those have been the first to really get further. So to be determined. And we wanted to leave some time for questions, so we're going to give some quick closing thoughts. And then if you all have any questions, we'd love to hear from you. Any closing thoughts, LaShawn?
Well, so to me, I think that if it's not broke, it doesn't need to be fixed. Meaning, I think that we can solve this whole issue by looking at it as a sampling scenario where, at some point the songs are gonna the credits are gonna look like the credits of a movie, but because you're gonna have so many creative parties that are in there. But most of the times when I see things like this happening, it's really because everybody wants to get paid and everybody wants credit for their work. So if we can figure out a way to get everyone paid and everyone credit, then the problem really, really goes away. And I think the solution is treating it like sampling.
Yeah, I agree with you. And I think with sampling, you have to get permissions, and that involves licensing agreements so that lay out everybody's rights. They keep you employed, and if you breach the licensing agreement, keep me employed. And it's not an automatic that we'll get there, but I think that's inevitable where we will be. Just a quick, I should have done this at the beginning. How many people here have actually registered their work with the Copyright Office? Okay. All right, so some of you have had some experience with this, and again, the takeaway is with AI, the examiners at the Copyright Office, they're looking at this technology that's new as well, and there are certain standards that they're supposed to apply now. It could be hit or miss whether your work, AI-assisted work, gets registered. It's a new world, and so you have to consult with an attorney. I know copyright. Anybody can register their own copyright. You can do that pro se, but if you want to avoid, particularly in the AI space, back and forth and rejections, consult with an attorney that's done this for a while and that's up to date on what the new requirements are involving AI so that it runs smoothly. And in the litigation space, yeah, it's a to be determined. I remember back when the new technology was the VCR machine, and the networks were sued Sony at the time, ironic, but Sony was the manufacturer of these VCR machines, and they were being sued essentially for aiding and abetting the copyright for allowing the public to record in their own living rooms, sitcoms on the networks. And technically, that could be a claim, a copyright violation. The trial court said no, That's not a violation. That's fair use, and you're not exploiting it economically. Went up to the Ninth Circuit Court of Appeal. Ninth Circuit Court of Appeal said, we're reversing the lower court. This is copyright infringement. We're going to remand this down to you to enter judgment for the networks. They took an appeal up to the Supreme Court, and the Supreme Court basically said, you know what, it could be under some circumstances copyright infringement, but not here where it's just being used in the home. And that took years to play out. And so hopefully it won't take that long for these issues to play out, and we will have learned our lesson to negotiate this among ourselves, among the industry players and the rights holders, to avoid the need for a 10-year litigation to assess these rights.
Love that. I appreciate that. I think first on how we got the copyright statute that we've been talking about is so old and amended over the years, but it really, copyright derives from our Constitution that talks about promoting useful arts. And I think that arts part, it's always something that's pretty subjective, right? Like what you consider art might not be the other person's art and things like that. And that's what's so interesting, I think, in having these conversations, because I love memes, for example, and that's where my head goes when you talk about that, because I do love music that also samples other music, and I do love memes that may use something that already exists, so an original work, and comment on it, or have launch that, turn that into a different perspective, makes you think, makes you comment on the original. So as much as we talk about fair use being a defense to copyright infringement, it's also a really important part of our copyright system, because those original works are not meant to last forever. There's an expiration date, and when that expires, that goes into the public domain. Now, I don't think that directly answers the question, but I think it gives us some thought into the original purpose of copyright, into what is art. And I initially think of the Supreme Court case involving Pretty Woman and Two Live Crew, right? And that was fascinating to think about, because a lot of people were criticizing them and saying, like, that's not okay. You're taking this beautiful song about Pretty Woman, and I don't like what you're doing to it, or maybe it's just that, come on, have your own original thought. So really interesting discourse, and I'm not saying yeah, you want to go? Okay.
So what I think that a lot of artists need to recognize is the need to properly identify and basically tag their work. So, blockchain isn't necessarily new. You had the ISRC before that, which was a number that each body of work was given so that another system could recognize that number and say, hey, if you ever see this number come up, this number goes to there. So it's the same philosophy with blockchain. As an artist, you're always gonna have, there's a such thing as a starving artist, and those starving artists, the song, it means something, because oftentimes those people do it for the passion, they do it for the love. Some people do it for the money. Usually the people that are only doing it for the money, it's a hobby, and they move along. The thing for, artists, people that respect their craft, they love it, they do it with a passion. What we now need to do is tap in and learn these new technologies and learn how to protect our craft, because a lot of times a lot of artists will come to me and they'll say, hey, I just do it for the love of it. I just want to make music. I just want to act. So they don't have a business frame of thought when they're creating this stuff. They're not creating it thinking, hey, this is a property that I'm creating, and if I created it and I take care of it, then it could potentially feed me, my family, and generations to come. So when I'm talking to people about intellectual property, I'm telling them that intellectual property is the same thing as real property. You have a home, you need a deed, you need a title, you have to pay more, you have to take care of that home, you have to upkeep it, you invite people in, you let them know what they can and cannot do. It's the same thing for the intellectual property. You've got to do things to protect your ownership rights in the property. So as an artist, the best thing that any artist can do, whatever the medium is to learn how to protect their property so that you have a lesser chance of this happening. Not to say that it won't happen, because bad actors are who they are. They sit around and they think all day of how they can game the system. But if you've at least registered your copyright, hired an attorney to have a document drafted. It's cheaper to get us on the front end to draft a document than to pay tens of thousands of dollars to litigate it. So take the time out, get your budget together, do those things to protect the property, and at least if someone does infringe, you have everything in place to go after them and properly protect your interests.
Just real quick, emotionally, I agree with you 100%. I mean, it's technology. You're hearkening back to the artist who sat there and wrote out the sheet music and was at the piano. Every phrase was this 4/4 time. No, here I'm going to switch it to 2/4 time. Yeah, I'm going to change the key. All of those things that were just basically using the artist's brain and physical talents. And I kind of the technology is sort of like the introduction of auto-tune for singers. You had the old school singers who just had the voice. They could hit the key. They had perfect pitch. They didn't need any accoutrements to improve their music. But now comes along auto-tune, and you have artists that employ it, and they're able to exploit their works. That's kind of where we are now with the technology. It's there. People are going to use it to create new works, and as LaShawn said, it's incumbent on the original artist to do everything they can to protect them. And I think that's what these lawsuits, for example, the one that we just talked about with Anthropic, that's a signal. Hey, artists, we want to protect the artists, the original artists, content producers' rights. Even if it's marginally infringing, we're going to go after you because you're not giving us any credit at this point. And again, so I agree with you, but I do think it will be worked out through the legal process and through the licensing process. Yeah, I think we had a question down here.
Yes. Do you foresee more artists taking the Taylor Swift route of re-recording their stuff to regain control of it for all the reasons you have explained?
I do. I see that all the time. I'm in discussions right now with a pretty major client that is going to re-record the music, and I mean, we haven't even touched on copyright terminations, things like that. So a lot of people, including myself, we've gone through the entire process of copyright terminations, but now it's okay, now what? What are we going to do? Are we going to sue these majors to force them to respect this termination? And then I also tell my clients, and once we claw back the copyright, how are you going to administer it? How are you going to work? You don't have time to do what the labels do. You're out touring. You're doing whatever. Who's going to say yes or no to these rights? Who's going to make sure that no one's exceeding the permissions that you've given to them? So my course path of least resistance is to go to the labels and say, hey, listen, we have this copyright termination. We don't want to control it, but we want you to give us a bigger percentage, because oftentimes those artists, they're getting like 13% on the net, and the label controls the net. And thankfully now a lot of the majors have gone in and they have this legacy forgiveness program now, where all of the labels are saying, as long as you haven't borrowed any money from the label in the last 10 years, we're going to forgive all of your debts that you owe. You no longer owe us any expensive. You completely recoup, and we're going to start paying you. A lot of artists don't know that the labels are doing that, because they're not going out saying, hey, we're going to start paying you. No, you gotta be in the system and know, hey, listen, so I've gotten clients paid because I'm like, I know you guys are honoring this legacy program stuff. We need to get paid. Like, we haven't borrowed any money. So, I mean, you've gotta kind of get it going. I'm sorry, I love this stuff.
analog and acquisition with AI. So when you were speaking about the chain of title, do you see any issues coming up when because the law is also changing on who would be the owner in an AI situation? So right now, the song we just talked about, where they sampled BBL Drizzy for "You My Everything" with Sexy Red, I see that the speaker has a composer credit, but it doesn't list, like, I guess, the AI company or the tool or platform. So do you see that being a part of the equation?
It's a great question. So we talked a little bit about the Copyright Office's perspective on that. And really, the other place to look for that is actually the terms and conditions of the specific platform that was used. So most of them have comments that address the outputs. So what are you doing with the information being put in? What's going on with the information that's being put out? And most of them are disclaiming, like saying that we don't own any rights. We're not claiming any rights to that. And I haven't seen any tech platform try to claim copyright. That would be very interesting. Copyright over the actual output. So that's kind of the other place to look, because it is so fact specific. We talked about a de minimis standard. There's kind of like, if you think of it on a spectrum of completely human created versus completely machine created, there usually people are falling in between. Even before AI really exploded with ChatGPT a couple years ago, there's usually some in between, because artists are still using some form of technology to assist with the creative process. Though on the spectrum, we are seeing it go a little bit more towards towards being machine created, whether it be entirely machine created. And that's where you get into very specific analysis with an experienced an attorney that is familiar with AI, and that's looking at these issues, like my friends up here, that will be able to speak to and know where to go for that kind of analysis.
I have a question for you, David. Wouldn't you think that in circumstances like what we're discussing as far as the AI programming, that, like you said, in the terms and conditions, the program they say we're not claiming ownership rights. I see that as kind of a safe harbor type of scenario where, like YouTube will say, we're not responsible for this infringement. We have the safe harbor because we're just a pass-through. We don't control anything that anyone's doing, how they're utilizing this platform. So is that something you think the AI programmers are really doing?
Yeah, so the terms and conditions, I mean, they're certainly trying to do that. So we had the Millennium Copyright Act that sort of did that for another, type of technology and platform that just said as long as you're a pass-through, you can't be sued for aiding and abetting infringement. And so far, I haven't seen any litigation against we've seen litigation against the platforms for just that, aiding and abetting infringement, because there is no Millennium Copyright Act equivalent currently for the platforms. So the platforms can, terms and conditions, they can disclaim, they can, say we don't own anything, and that helps the artist. It doesn't help them on the other side from the original content creators from being sued. So vis-a-vis the new artist, I think they can protect themselves. I think that the new artist that created it isn't going to have a problem with the platform claiming we own that, because most of them are putting in their terms and conditions just that caveat. But again, it's all of the litigation is coming from the other side, the original content creators suing the AI platforms right now. What we haven't seen is the original content creators suing the ultimate creator using the AI. I haven't seen that litigation yet. If it's out there, it hasn't been reported, at least to my knowledge, or might be in some state court, but so far the music publishing companies have targeted the big, deep-pocketed AI generating companies. They haven't gone after the new creators yet. And that's similar to what happened with Napster. It was going after the bigger companies, and then at the end they went after 4 college kids, who were downloading stuff in their dorm rooms. Everybody became irate, and by that time we had new models for the situation. We'll see if that happens with this.
And my question is connected to what you just said. Given the fact that most of these disclaimers are also stating that they can use whatever data that they're getting from these ingestion points, the artists who are actually creating, most of these platforms seem to also add in their disclaimers that they are more than free to use whatever it is that you're putting into it. How do you see that maybe complicating the situation of copyright going forward?
Yeah, so it's a great question, and it's coming on the heels of a really big controversy involving Adobe's recent updates of their terms and conditions. So people were, there was an artist that, I think, it all started on Twitter, I refuse to call it X, that said something about, look at these terms and conditions. I'm giving a license, I'm giving permission for Adobe to use this for whatever purpose. Or at least that's how it was that's how it was kind of taken and gone with it. And I think there's a lot of misconceptions around that. You're going to find that nearly every platform has a license, or you're giving permission to whatever platform that you're using, like whether that be your email, Adobe, or whoever else, that some electronic tool that you're using. They're going to say, we need permission to use what you're giving us so that we can look and see if there's any problems, address any bugs. If you come to them and have an issue, they can help you fix it. Like, that's usually the purpose, and you'll see there's usually limiting language right before that license and giving permission that can help make that more clear. But all that is to say that people are being extremely cautious. I'd say a lot of the technology companies, I like to think, are taking a deep look at what they're doing with the data and for what purpose. That's usually going to be in your privacy policy. I know we talked about that last time, and how the Federal Trade Commission has been very, very active in the privacy space, and they're being very active in the AI space as well, looking to make sure, because I think part of what you're asking here is like, what are you using what I'm putting in your program to train your models, right? Because that's where the 2 big issues are coming from. The training, what are you using to train your models? And then the output part, which we've mainly been talking about, the output part.
And of course, everything that you input is subject to being used for advertising purposes. So you're going to get hit with that.
Sorry, how do you see that complicating the copyright and IP issue for artists?
Okay, go ahead and answer that question. That's going to be the last one for you guys, okay?
I'm sorry, can you repeat that? I didn't.
Does it complicate the IP issues for the artist?
Yes.
Yes, I mean, because the artist is the one using the platform, and so the artist is the one that's interacting with the platform, and it's the artist's information that is being used one way or the other by that platform. And so understanding those terms and conditions, which I know nobody reads, you need to, as this is your profession, this is your avocation, read those terms and conditions, because it's going to affect how much of your data they can use and where they can use it. Sometimes it's the data they're using is not the creative part that you're worried about. It may just be your location and where your IP address came from. If it's something banal like that, okay, maybe you don't care, but you really need to read the terms and conditions.
Opt out. Most of those programs, they have opt-out provisions. You can opt out a lot of things. You can opt out of geolocation and things like that. Sorry, thank you. You can opt out of geolocation tracking and all of these different things. So opt out is really just an email. Hey, I want to opt out of this right that you are attempting to secure.
And we didn't even talk about brand management, but that's where my head goes with that. So important for artists to consider what you're giving over to specific platforms. Not all platforms have the same terms, so take a look at it before you use it.
Thank you so much.
Thank you.
LaShawn Thomas, Jessica McDonald, and David Millian. Thank you.